The Secure Act came as an unwelcome gift to many. The act was signed into law on December 20 of 2019 and is effective as of January 1st of this year. It affects your retirement accounts such as 401k, 403b, IRA, etc. And mainly, it affects them in the way how they're treated after you die. Before the Secure Act, if you leave your retirement account to your child or children, they could stretch the money over their life expectancy. What it means is that they would have to start taking out small distributions every year, but depending on how old they are, they could keep the money in the account and postpone paying tax for a long time. Under the new law, with some exceptions, your children will have to draw the account down in no more than 10 years. They can no longer stretch IRA distributions from inherited accounts, and the chances are that your children will still be working at the time of inheritance, so their effective tax rate will be higher than yours when you are retired. In other words, you cannot really treat your IRA as a savings account that you can leave to your children, then to your grandchildren, and so on and so forth. Now, retirement accounts are exactly what the name says they are. They are your retirement monies, money for you and your spouse to spend on your retirement. Under the new rules, some beneficiaries are still exempt from the restriction on stretching IRAs. Those beneficiaries are eligible to stretch distributions over a period longer than 10 years. Now, who are those people? First, spouses. Spouses can roll over the IRA and the minimum required distributions will be recalculated based on their life expectancy. Also, disabled and chronically ill individuals. Minor children of the account holder until they reach the age of majority, then they will have 10 years to draw the account. And beneficiaries who are less than 10 years younger than the account holder. The impact on your estate plan may be minimal or huge, depending on how your plan deals with your retirement funds. For example, if you have your trust named as a beneficiary of your IRA and it's a conduit trust as opposed to an accumulation trust, call your attorney today. Make sure that your plan is revised. Generally speaking, with the new law in place, you may need to not only revisit your estate plan, but rethink the way, how and when you utilize your retirement funds. In other words, it might be better to spend your retirement money on your retirement and preserve other assets for your children and other beneficiaries. My advice, speak with your attorney. In most states, inherited retirement accounts are not protected from creditors. While your IRA is generally protected in bankruptcy during your life and the life of your spouse, it's no longer protected once transferred to your children. Also, what many people don't know is that retirement accounts are not protected from your long-term care costs. And depending on what state you're in, if you or your spouse need a long-term care or nursing home, you may not qualify for Medicaid until you draw down and spend your retirement funds. Planning for qualified retirement accounts is very complex. Make sure you consult an experienced estate planning and elder law attorney before you take any steps or make any changes to your existing plan.
Milvitsky Law Group is a full-service elder law and estate planning law firm. With 4 offices located in Paramus, Morristown, Jersey City, and Red Bank, we serve communities throughout New Jersey and New York. Call us at 201-380-2000 or visit us online at www.thelawofaging.com. Make sure that you subscribe to our newsletter to stay up to date on important developments in estate planning and elder law.